Companies Act, Section 161, Appointment of Additional Director, Alternate Director, and Nominee Director. Section 161 of the Companies Act provides a structured framework for the appointment of directors in specific circumstances where the company requires additional, alternate, or nominee directors. This section ensures that companies have the flexibility to fill vacant positions, appoint temporary replacements for directors, and accommodate nominations from external institutions or government authorities. The section defines 4 key types of directorship appointments. Additional Director, appointed temporarily to expand the board. Alternate Director, a replacement for a director who is absent for a specified period. Nominee Director, appointed in compliance with legal or contractual obligations. Director in a casual vacancy, filling a vacancy arising due to an unforeseen departure of a director before the end of their tenure. This provision empowers the Board of Directors to make these appointments subject to the company's Articles of Association and necessary approvals. 1. Appointment of an additional director. A. Power of the Board to appoint additional directors. Under Section 161, 1. The Board of Directors of a company may appoint an additional director if such power is explicitly granted by the Articles of Association of the company. B. Restrictions on appointment. A person who has failed to get appointed as a director in a general meeting cannot be appointed as an additional director. The appointment must align with the provisions of the Companies Act and other applicable regulations. C. Tenure of additional directors. An additional director appointed under this section holds office only until the next annual general meeting, AGM, or until the last date on which the AGM should have been held, whichever is earlier. D. Rationale for additional directors. This provision helps companies manage unexpected board-level vacancies without waiting for a shareholder meeting. It allows companies to bring in qualified professionals when needed. 2. Appointment of an alternate director. A. When can an alternate director be appointed? Under Section 161, 2, the Board of Directors may appoint an alternate director if the company's Articles of Association allow for such an appointment. The shareholders have passed a resolution authorizing the board to make such an appointment. The original director is absent from India for at least 3 months. B. Restrictions on appointment. An alternate director cannot be appointed for a director if they already hold an alternate directorship in the company or serve as a director in the same company. An alternate director for an independent director must meet the qualifications of an independent director under the Companies Act. C. Tenure and automatic termination. The alternate director cannot hold office beyond the term of the original director. The alternate directorship automatically terminates when the original director returns to India. If the original director's tenure ends before their return, the reappointment provisions for retiring directors apply to the original director, not the alternate director. D. Purpose of an alternate director. Helps maintain continuity in board decisions when a director is temporarily unavailable. Ensures that the company remains compliant with legal and governance requirements despite a director's absence. 3. Appointment of a nominee director. A. What is a nominee director? A nominee director is a director appointed to the board to represent the interests of an institution, government authority, or shareholder under a legal or contractual obligation. B. When can a nominee director be appointed? Under Section 161, 3, the Board of Directors may appoint a nominee director if the company's Articles of Association allow such an appointment. The appointment is made under the provisions of a law, agreement, or government directive. A government body holds shares in a government company and exercises its rights to appoint a nominee director. C. Purpose of nominee directors. Protects the interests of investors, financial institutions, or government stakeholders. Ensures compliance with contractual obligations or regulatory requirements. 4. Filling a casual vacancy in directorship. A. What is a casual vacancy? A casual vacancy occurs when a director appointed in a general meeting vacates their office before their term ends due to resignation, death, disqualification, any other unforeseen circumstances. B. Power of the board to fill a casual vacancy. Under Section 161(4), the Board of Directors may fill such a vacancy subject to the company's Articles of Association and regulatory requirements. C. Approval requirement for casual vacancy appointments. The board must approve the appointment at a board meeting. The appointment must be subsequently approved by shareholders at the next general meeting. D. Tenure of a director appointed in a casual vacancy. The newly appointed director holds office only for the remaining term of the original director. If the original director was subject to automatic reappointment, this provision applies to the original director, not the replacement. E. Purpose of filling casual vacancies. Ensures the company's governance structure remains intact despite unexpected vacancies. Prevents board disruptions that could affect strategic decision-making. For more details, contact us.